Hello everyone and welcome to today's Mondac webinar in association with Busy Lance Legal Consultants covering the personal data protection framework in the UAE. My name is Dan Sampaio and I'm joined by a wonderful panel to take us through today's discussion. Saifullah Khan is an international trade, IT and policy lawyer with more than 20 years of diversified and multi-jurisdictional professional experience, serving a large client base in the domestic and international markets. His areas of interest include trade remedy laws of the World Trade Organization, customs law, competition law, and data privacy. With respect to the emerging discipline of data privacy, he advises clients from different jurisdictions on data privacy compliance and cross-border transfer of data. Alfred Strolla is the founder and CEO of Strolla. Alfred was a general senior partner in the Deloitte and Touche Middle East practice. Alfred is a certified public accountant of Ireland and the UAE. He possesses over 40 years of successful professional experience providing audit and assurance, tax consultancy and financial advisory services to a range of clients in the Middle East and Europe, and brings with him a wealth of experience in the GCC region in assurance and advisory engagements. And completing today's panel is Saeed Hasan Khan. Saeed has more than 20 years of experience advising clients on issues such as taxation, corporate, regulatory compliance, and contractual obligations, and in representing clients before the authorities. Mr. Khan has developed a keen professional interest in emerging laws on personal data protection and has gained an understanding of the underlying concepts and principles governing global data protection laws, including the EU's General Data Protection Regulation. Now, before I hand over to the panel, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during the Q&A session, but please do reach out to them after the webinar for any additional information. It's now my pleasure to hand you over to Saeed, Saifullah and Alfred to begin. Thank you.
Thank you very much, Dan, for the introduction. And I would briefly start, and then Alfred Strolla will follow, and finally Saeed Hasan will end the presentation. There is a lot of echo nowadays about the laws on personal data protection, and most of us have been frequently hearing about the data protection regulation in the European Union and the cases being undertaken by the authority in Europe. I would briefly explain in my presentation why there was a need of personal data protection law and why they have been developed and enforced in different jurisdictions. I will not talk about the regulatory provisions or the legal provisions of any particular law. My fellow colleagues will talk about the legislations in UAE and other jurisdictions. Actually, as we know that the personal data protection is all about the right of privacy, to protect the privacy right of the natural person, the individuals. And that right actually empowers the natural person on a certain key indicators that I will show in my presentation. Can we move on the slides? Okay, so firstly, I'll talk about that privacy of individual and then the rights of privacy, the rationale behind these laws in different jurisdictions, the data protection and privacy legislations worldwide, and what the personal data protection law is all about. Briefly, a few very basic concepts, and then rights of the data subjects and the obligations of data controllers. Next slide, please. Okay, so coming towards this first slide, I was telling that we have heard about the GDPR, and the basic concept of these laws is the protection of privacy of individuals. And what the privacy right gives to the natural person, actually it depends upon certain key determination that when the personal data of an individual can be used by others, how others can process your personal data, and for what purpose others can use your personal data. So these are the key determinations in each and every legislation. And I would like to say that obviously, yes, if the right of privacy is protected in a society, obviously there is a very, very positive impact on the behavior and actions of the individuals. And resultantly, what it ensures is the human dignity, the safety, and the self-determination. And when we talk about the human dignity, it is about the right of the individual to be valued and respected for its own sake, and be treated ethically by all means. When we talk about safety, the safety means safeguarding the privacy of the individual. And when we talk about the self-determination, it means that the individuals have the control over their own personal data, meaning thereby they may be able to choose how their personal data may be used and for what purposes. So they have the control over their own data. Next slide. The right of privacy actually is traced way back to 1948 when the Universal Declaration of Human Rights was adopted by the UN. The Article 12 is the relevant article for us, which says that no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. Everyone has the right to the protection of the law against such interference or attacks. So essentially, these laws provide protection to the individual rights of the data subject, which is the natural person. And we will be discussing the same concept later on in the webinar. Next slide, please. If we talk about the rationale, which is a very important background of the reason why these laws have been developed, these are four basically rationale about the basis of such laws: protection of individuals, right of privacy, empowering individuals, business enabler, and necessity of time. And I will explain all of them one by one in the subsequent slide. But before moving on to the next slide, I would like to point out that there had been difference of opinions, and still there could be difference of opinion about the enforcement of these laws and regulations in different jurisdictions, because there are two school of thought. Some of them believe that probably the such kind of regulations on data privacy law would hamper the growth of IT industry, and it might also slow down international trade. But there is another school of thought which says that it is very much required and it is very much needed for the protection of the privacy right of the individuals. I remember that in 2018, during the fourth e-commerce week in the Geneva by UNCTAD, United Nations Conference on Trade and Development, where I was participating as a speaker and a moderator. We had a discussion on a number of sessions about this issue, and there were difference of opinion noted at that time as well. But still, I would say that the governments in different countries, they believe that it is an important regulation which should be enforced. And even after 2018, there are a number of countries in different regions who have adopted this law. Like in Gulf, if you talk about Gulf, UAE, then Bahrain, then Saudi Arabia, they have developed this law after 2018, I'm telling you. And if you talk about Africa, the Nigeria has this law, South Africa, even in China, and if you talk about South America, Brazil, and even one of the countries, Egypt, in the African region. So these countries have recently developed laws on personal data protection even after 2018. So in spite of having a different difference of opinion, I think most of the countries now, they realize that they have to have this law. Next slide, please. The protection of individuals' right to privacy has to be ensured, but how? The question is how that can be ensured. Without having a regulatory framework or the legal framework in your country, you cannot ensure the right of privacy of individuals. So that means you have to have a law. And once you have a law, then that law gives birth to the regulatory authority or enforcement authority in your country. And that enforcement authority or regulatory authority, they work as a deterrent for those who process personal data of the individuals. And at the same time, those authorities, they provide a platform to the individual natural person for the redressal of their grievances if there is any breach of their private or personal data. And moreover, these laws and regulations, they also provide harmony, uniformity to all the stakeholders. Either you are an individual as a data subject, or you are a data processor who is processing the individual's data, or you are a regulator. So everybody would be certain about their rights and obligations. And that can only be achieved if you have these laws in force and the regulatory framework in force in your country. Next slide, please. The laws on personal data protection, that definitely helps individuals in many cases. The first one is obviously the right to privacy is preserved, and that can only be preserved if you have the law in your country. And then it also empowers the individual that he has a control over his own data, and they can decide that how and for what purpose their data can be used. So it gives a right and empowerment to the individuals. And finally, this enforcement right to protect the personal data can be achieved, obviously, with the regulations in place. Because these regulations, as I said earlier, provides a complete redressal mechanism for the data subject, that if there is any kind of infringement to their rights of protection of personal data, they can always come to the authority and knock at their doors. Next slide. There is a very positive implication of having such laws and regulatory frameworks in your country for business entities, because the businesses or the companies who are compliant with the regulatory framework of their country, they get more trust and loyalty from different stakeholders. The customers would feel more easy to share the data and transfer the data to even other jurisdiction if they know that there is a legal framework, very well placed legal framework is there in the country where they are sending their data. And what the result would be for the company who is fully compliant, they will get more expansion in the global market. They will get more recognition in the global market. Obviously, people would like to work with them. Thirdly, they would get a competitive advantage over the non-compliant companies. So obviously, if a company is fully compliant with the data protection law of their country, or if you talk about the UAE, although we are waiting for the executive regulation to come, the law is already there. So the companies who will follow the law quickly, and if they get themselves fully compliant, they would be seen much better and more trusted as compared to their competitors. Likewise, obviously, if you comply with the regulatory framework which is in your country, you will be getting more market share in the digital economy. I would give you one example about McKinsey. There was a study done by McKinsey in the year 2020 for North American customers about the collection of personal data. And as a result of that study, the result was 87% of the customers, they said that they would not like to work with the companies who do not have a secure system for the protection of their personal data. And likewise, 71% of the consumers and the customers were of the view that they would not like to share the information, their personal information, with the companies who share their sensitive information with the third party without their consent. So it has a very, very, I would say, a direct consequence for the business. And those who are compliant will take the benefit, and those who would not compliant will lose the business. Next slide, please. The necessity of time is to have a regulatory framework is very obvious, because we all are living in the IT era. We prefer to perform all our transaction digitally, either it's a banking transaction, shopping, or travel arrangements. Even education and training is being done electronically. Even the business and the commercial transactions are being preferred now to be performed electronically. So under such a situation, when you prefer to perform all your your personal transactions, either banking or others, through electronic means, this means that you are sharing your personal data. And sharing your personal data poses the personal information to vulnerabilities. And in order to avoid such a vulnerability, you need to have a law, the regulatory framework in place. So until and unless you have a proper regulatory framework in place, it is difficult to ensure that your personal information, which is going from one place to another electronically, will be secured. It would be difficult. Next slide, please. The social media, we all know. The social media use is extensive nowadays. The cross-border flow of personal data is quite extensive. In a social media, if we talk about social media, we use our photos, we share our photos, we share our videos, we share our audio notes through social media, and even other personal identifiers, which all are personal data. So if we are frequently, and as we are frequently sharing our personal information on social media, so quite often we need proper law for the protection as well. And if there is no proper regulation in place, the misuse of data could be it could identify theft. It could result into unauthorized access. It could result into financial loss, and it could result into a reputational loss as well. Next slide, please. Data protection and privacy legislation worldwide. Do you hear me? I think it's okay. Do you hear me properly?
We can hear you, Saifullah. Thank you.
Okay, this graph actually shows the data protection and privacy legislations worldwide. So if you see, there are different countries in different parts of the world who have the data protection law in place already. Next slide, kindly. So out of 194 countries, 137 countries have already put in place legislation to secure the protection of their personal data and privacy. 71 countries, they already have, 71% of the countries have already have the legislation. 9% of the countries, they have the draft legislation. 15 countries, they have no legislation. And 5% of the countries, they have no data by UNCTAD, because these statistics have been taken from UNCTAD. So they believe that for 5% there is no data available. So these percentages, the statistics clearly shows that the global economies and the world leaders, they have taken cognizance of the fact that the personal data protection is the need of the requirement right now. So everybody appreciates that they need to have a personal data protection law, and they are following it. Next slide, please. Okay, now the question here is that what the personal data protection laws are all about. One thing is to be very clear. One thing should be very clear in our minds, that the laws on personal data protection, they do not try to restrict the use or the exchange of personal data. Neither they could, because it is the necessity now of exchanging personal information from different means. The only thing these regulations and laws, they just want to regulate the use of an exchange of personal data by having a suitable regulatory framework. And what that framework does is it provides protection actually of personal data of the natural person, which is called data subject, and give them rights to ensure the protection. And then there is an obligation. The users of the personal data, which we call data controllers and the data processors, they are obliged to ensure that the protection of personal data is in accordance with the provisions of the personal data protection law in their country. And about the enforcement, the laws are implemented and enforced by a public sector regulatory authority having powers to process complaints and to impose fines. Next slide. These are some very, very basic few concepts which I would like to highlight here, because you are going to have details in the next presentation. The personal data is any data which is related to any identified or identifiable natural person, and data subject is a natural person to whom personal data relates. Data controller is the one who determines the purpose, methods, standards of processing of the personal data. And then comes the data processor, the one who processes personal data on behalf of the data controller. Next slide, please. The laws, all these laws on data protection law in every jurisdiction, they provide rights to the data subject. The data subject is the natural person whose data is collected. And few of the rights are the right of access to information, a right to request personal data portability, a right to rectify or erasure, right to restrict processing, a right to stop processing, right to object automated decision making, including profiling, and right to withdraw consent. Now, all these rights have to be respected by the data processor, data controller, because in case you do not give these rights to the data subject, then you will have to face penalties. I'll again give you one example. In the year 2021, Austrian Post, they received a fine of 9 million euros. And why they received this fine? Because they did not agree on emails which they received from a data subject as a notice, as a right for the data subject to inform the data controller about any of these rights of communication. So what the Austrian Post says that we can have your communication through postal mail, we can have your communication through other means, but they avoided, or they did not accept the communication by email. But the Austrian authority says that if a data subject sends you an email, and if he wants to exercise one of the rights which you can see right now, that are in front of you, then that email should be considered as a proper way of communication of exercising the right by a data subject. So what I mean to say is that the data processor and controller have to respect these rights by all means. If they do not respect the right of the data subject, they will have to face huge penalties. Next slide. Then we talk about the obligations of the data controller and the data processor. Now, this is one who is collecting the information and processing for a particular purpose. Few of the obligations are only to process personal data with the consent. Obviously, without the consent of the data subject, you cannot process the information. Processing must be fair, transparent, and lawful. Now, this is called a lawful purpose. The data collection by a data processor or a controller can only be for a lawful purpose. Processing only for a specified purpose. So this is called purpose limitation. You have to tell the data subject the purpose for which you are collecting information. Only to use personal data which is necessary for the specified purpose. This is called a data minimization. You cannot collect information much more than required for a specific purpose. You only have to collect the information which is relevant for the processing of a particular purpose, which is a lawful purpose. Then not to keep personal data beyond the time for which it was collected. Then the obligation is the accuracy and the correction of personal data, and the safety and security of the personal data. I will again give you one example about the obligation. There was a case in 2020 by Data Protection Authority of Germany, and they imposed penalty on H&M amounting to 35 million euros. Why? Because H&M was collecting much more information of the employees, which was actually required for processing of their employment. So H&M was penalized by 35 million euros. But why you are collecting so much of information, extra information, which is not needed for processing of the employment? So you have to respect the right of the data subject, and then as a data controller, you have to fulfill your obligations as well. So this was the background which I wanted to give as a startup for this webinar. And thank you very much. I will hand over to our very learned speaker, Alfred Strolla, and the floor is yours, Alfred.
Thank you very much, Saifullah. That was very useful, very informative. I will quickly now take you to very important subject, which is the cross-border transfer of data and our protection, the data protection officer. And these subjects are a must in every law that we have seen. Almost 75% of the world now is adopted. The main subject I'm going to, please, next page. Cross-border transfer of personal data. We will briefly go through the UAE law, the ADGM regulation, and the DIFC law. And of course, then the data protection officer, which is a very important person, depends on the volume and the transactions that each company is supposed to maintain. The UAE, the ADM regulation, the DFC law, responsibility of the DPO, the data protection officer. Next slide, please. The UAE Law on personal data protection regarding cross-border transfer and sharing personal data under Article number 22 of Data Protection Law number 45 of 2021 is very clear that personal data might be cross-border transferred from UAE with very strict measures and adequate level of protection. To a state or authority having strict personnel data protection. So you cannot just transfer data for another state or a territory when you have to make sure that where the data is transferred to, they have equal laws and equal regulations that protects that data from being misused. So the data subject can exercise the right related to the imposition of appropriate measures against the data controller or processor through a regularity or judicial entity. Without that, is not permitted according to the UAE law number. To a state or territory with whom UAE has bilateral or multilateral agreements in respect of personal data protection. Unfortunately, currently there are no agreements with any state authority as we speak. But of course, there will be more executive regulations which will clarify that. The executive regulation yet to be issued will provide further guidance on the cross-border transfer of personnel data. Next slide, please. The ADGM, the Abu Dhabi Global Market Regulation, and the DIFC law, they require adequate level of protection. And they're very, very strict, both free zone, financial free zones in the UAE, one in Abu Dhabi and one in Dubai. They're very, very strict about the personal data. The personal data may be transferred outside ADGM or DIFC on the basis of equal level of protection that they have in accordance with the laws of the ADGM and the DIFC. Appropriate safeguards in the absence of any adequate level of protection personal data may be transferred outside ADMDAS on the basis of appropriate safeguard. The appropriate safeguard include a legally binding instrument between the public authorities. Next page, please. Binding corporate rules, standard data protection clauses, approved code of conduct, and approved certification mechanism. Now, I'll give you one example, which is of specific situation in ADGM data protection law. In the absence of an adequate decision pursuant to section 41.3 or 41.7 of the ADGM data protection law, or the appropriate safeguard pursuant to section 42, include binding corporate rules, a transfer of personal data outside of ADGM, or to any international organization must take place only in the conditions specified under section 44 of the ADGM data protection law. So it's very, very strict. You have to know about these laws and regulations before you transfer any data outside. Next slide, please. Now, the UAE law on personal data protection regarding data protection officer, here what we call DPO, or in brief DPO, under article number 10 and 11 of the Data Protection Law number 45 of 2021. The DPO, the Data Protection Officer, is required to be appointed when the processing is likely to result in a high risk to the privacy and confidentiality of the personal data due to adoption of new technologies or due to volume of data. Now, if you have this, you are obliged and you have an obligation to appoint a DPO. DPO is also required to be appointed where the processing involves a systematic and overall assessment of sensitive personnel data, including profiling and automated processing. Because of automation and hacking and all these sort of things, you have to have a very, very system-proof and actually all hacking and firewall, all this protection in place to make sure that these data are not really filtered out of your organization. The ADGM regulations, DPO is required continuous. DPO is required to be appointed where processing is carried out by a public authority, except for force acting in their legal capacity. Of course, if you have a court order, if you are asked to present it, then you have to comply with it. DPO is required to be appointed where core activities of controller or processor which require on the basis of nature, scope, and purpose of processing, regular and systematic monitor of data subject on a large scale. DPO is required to be appointed where core activities of the controller or processor consist of processing of large scale or special categories of personal data. Next slide, please. The DIFC law, DPO is required to be appointed by the Commissioner, the DIFC Authority, and by the Dubai Financial Services Authority. DPO is required to be appointed by a controller or a processor performing high-risk activities on a systematic or regular basis. A controller or processor, both then above, may be required to designate a DPO by the Commissioner. Next slide, please. Now, there are certain responsibilities which we have to address very appropriately. Responsibility of the DPO common in UAE law, ADGM regulation, and the DIFC law. The responsibility of the DPO, among others, include monitoring the compliance of data controller or data processor within the applicable legal framework, informing and advising the data controller and data processor and their respective employees who carry out personal data processing about their obligation under the applicable legal framework. Here, this requires a lot of training from each entity and proper advice and continuous monitoring that this is observed. Acting as a contact point for the concerned regulator. So you have to have somebody who is always in contact with the regulator and updating him on this process. I would like to thank everybody. I will transfer you to my colleague, Saeed Hasan Khan, and he will take you from here. And after that, we will take your question and answers accordingly. Thank you very much. Saeed, please, can you?
Thank you, Alfred. Thank you, Saifullah. You have given a very informative presentation and information during your presentations. And hello to everyone. Today, I will be discussing some basic concepts which are common in various jurisdictions, and especially under the United Arab Emirates law, to understand the whole process of personal data protection. established in very detailed mention the rationale behind and the jurisprudence behind the promulgation and enforcement of laws on personal data protection. So my presentation and my intervention will be will highlight what these basic principles are and what basic guidelines are there in the law to be followed by the person to whom this law is applicable. So next slide, please. I will give an overall overview of the topics or the topics which I will be discussing. I will be discussing about the legal framework, what law is applicable in United Arab Emirates, and an overview of the UAE law, how it works. Then, more importantly, I will spend some good time to define and to explain a few definitions within the law, which I say some terminologies or the concepts which are too necessary to understand the legal framework. Then I will discuss about the applicability of the UAE law, then what is the regulator do to enforce the law, and then there is an important topic about the consent of the data subject, and then I'll be discussing in details. Saifullah is already highlighted, but I'll be discussing in some further details what rights are available to the data subject and what does it mean. And then what obligations the data controllers have to fulfill to comply with the requirements of the legal framework. Then there is a topic of data breach notification. I'll discuss about that, and in the end, I will be discussing about what are the fines and what are the administrative sanctions in case there is some violation or contravention of the legal framework. So next slide, please. In UAE, there are three regimes of the law, the codified law, available and working. The first one is the Federal Decree Law number 45 or 2021 on personal data protection. It is a federal level law and is applicable across the 7 Emirates. Then there are two specific laws specifically applicable on two financial free zone. One is Abu Dhabi Global Markets, and the name of the law is ADGM Data Regulations 2021, and the other financial zone, free zone, which is DIFC, Dubai International Financial Center, and the law is applicable there, law number 5 of 2020, the DIFC law. During my intervention, I will mainly be focusing on the legal provisions as contained in the mainland law, which is Federal Decree Law number 45 of 2021 on personal data protection. Next slide, please. The laws on natural personal data protection all across the world and including UAE have interconnected three spheres, and this slide is very important to understand the whole concept of the law. So at the first stage, the first sphere are the natural person like we all. The law is meant to protect the personal information of the natural person. So the first sphere is the natural person who have got the rights, because the purpose of the law is to protect the interest or the protection of personal information of the natural person. That's why extensive rights are given to the data subjects. On the second side comes the so you can see data subjects have got the rights, and then comes on the second sphere comes the persons who use the personal information of the natural persons. They are called as controllers or the processors, and the law, in order to protect the natural persons, have placed certain obligations on collectors and processors. So the collector and processor have to comply with these obligations. At the third stage, there comes a regulator. The purpose of the regulator is to regulate and implement and enforce the law. Under the UAE law, data office is the regulator who has to regulate the law. I will discuss in detail the rights of the data subjects, the obligations of the controller, and the functions of the regulator in a while. Next slide, please. So as I mentioned that to understand on a holistic view, what is the personal data protection all about is we need to understand or to know some basic concepts which are part of the law as a definition given in the law. So I will start my the first concept I will take to explain to the audience is personal data. Very interestingly, the name of the law is Personal Data Protection Law. So the personal data, to understand what is personal data is very important. So the legal definition which is contained in the law is there in the slides, and which is quite inclusive and quite detailed one. But if I can say in a simpler words that personal data is any information which directly or indirectly is capable to identify a natural person. So it is a personal data. So some quite obvious examples are like my name, my email address, my physical address, my passport number, my social security number, my driving license number, my voice note, my pictures, through which I can anybody can identify myself is a personal data. So next slide, please. Another important concept is sensitive personal data. In fact, the sensitive personal data is part of the personal data, but is defined separately because of the reason that to process the sensitive data, personal data, they are putting some extra measures to protect the data while they are being processed by the data controllers. So simply, the sensitive personal data includes like biometric information, religious beliefs, biometric genetic data, or the philosophical or religious views, so or the criminal data also. So this is purposely it is kept separate from the personal data definition of personal data to give more importance for the data controllers to be more focused or to be more attentive while processing this sensitive personal data. Then there is a concept of data subject. Saifullah has talked about it briefly. So data subject is natural person. As I mentioned, that the purpose of the law is to protect the personal information of the natural person. So the term which is being used all across this legislation is data subject. So myself, I am a data subject for the purpose of this law. Any person, any natural person who is subject matter of personal data protection law is called data subject. So whenever we see or listen any the terminology data subject, it means a natural person in the context of personal data protection legislation. And next slide, please. The next two concepts or definition which I would like to highlight are the persons who use the personal data of the natural persons. So one is the controller and the other is processor. So the definition is different, and later on during my presentation I will give some factors which can distinguish or which can differentiate between who is controller and who is processor. And this definition is important for controller and the processor to understand, because the law gives different set of obligations and the requirements to meet by the controller or processor. So the person or the company or a business must know whether it is a controller or the processor in order to imply or to comply with the requirements. So the controller is simply a person. It is a detailed definition given in the legal terminologies, but in simple words, I would explain for my audience that a controller is a person like a company who decides to collect the data, who decides to collect and determines the collection of personal data. Just an example, if, for example, a university or a college, while taking new admissions for their degree program, they ask the students or the applicants to give their date of birth and anything, and so that means they are deciding to collect the data. They are determining what data is to be collected. So the university or the college is for that matter controller. Now, what is a processor? Processor is a person, it may be a company or a natural person, who acts on the directions of the controller. The processor is one who cannot by itself decide to collect the data, but he is the person who is only to act under the instructions of the data controller. In simple words, we can say processor is a third-party service provider who provides services to the data controller. So after that, next slide, please. Very important concept of consent. Consent is heavily recognized mode of permission or mode of using personal data to the data controllers, which means that without consent, or the data controller must have obtain a consent for the data from the data subject before it can process the data. So in simple words, the consent, the meaning of consent is very clear, but there must be three ingredients present in the consent. Consent must be clear, it must be specific, it must be unambiguous. I will give afterwards a few examples upon the nature of the consent, why it is so important. And the next slide, please. Okay, we are talking more about the processing of personal data. Always when we listen about the personal data protection laws, there is a word or a terminology used, processing. So what is processing? Processing is a very extensive and all-inclusive definition, which I say it starts right from collection of data till the erasure of data. So what action a data controller takes right from the collection of the data until he transfers, he process, he validate, he makes some alteration, he make adaptation, he storage, recording, structuring, and even sharing with others. Disclosure is also part of the processing. So anything a data controller do on the personal data right from the collection till its final destruction or erasure is processing. The next slide, please. The last concept or definition which I would like to discuss here is personal data protection. You remember that I started this definition of the concept from the definition of personal data, which is part of the title of the law, personal data protection. So now I am talking about the whole title of the law is personal data protection, and this term is defined here. What is personal data protection? So again, in simple words, personal data protection are the technical and organizational measures which a data controller or a person is to take in accordance with the law in order to protect the personal data. So the personal data protection definition is already there, as always is there in the law. Just to explain what does it mean and how it can be protected from vulnerabilities. Next slide, please. To continue my discussion about the significance and the importance of these few concepts which I defined about the personal data, consent, and all of the definition, I will choose a few examples to highlight why, from a compliance perspective, if when this law is applicable to a company, so the company or the business need to understand what is personal data, so that it can identify the law is applicable on which data and law is applicable on or is not applicable on which data. So my question over here is to audience is whether an exam script is a personal data or not. So this is a case study. It was an actual case happened. A candidate was there in Ireland who appeared in an examination. When he failed, he requested his examining body to share or to give him access to his exam script, considering that his exam paper or exam script is personal data. The request of the candidate was rejected because the examining body was of the view that examination answer paper or the examination script is not a personal data to be shared under the laws of the personal data protection. The battle goes on and it went up to the stage of Court of Justice of the European Union. And it's very important what the Court of Justice at European Union held. I'll read it out loudly. The written answers submitted by a candidate at a professional examination and any comments made by an examiner with respect to those answers constitute personal data. So I'll go back to my simple word definition that any piece of information which can directly or indirectly identify a natural person is a personal data. So the Court of Justice in European Union held that even the examination script is also a personal data. So next slide, please. So I have talked about the consent. So what is the significance of consent? Just another example, there was an online lottery service in Germany, and when the user logged in to use the lottery service, there was two tick boxes. One was the unchecked tick box to receive third-party advertisements, which the user can tick at his own choice, and the second was a pre-ticked box, allowed the online lottery service to set cookies to track users' online behavior. Next slide, please. And next slide, please. So the question which came before the Court of Justice of the European Union was whether a pre-ticked box is a valid consent or not. I would emphasize that the user of the online lottery service were able to uncheck this. I mean, if I'm a user of the that lottery service, so I can uncheck this by saying I am not open to to use cookies for my machines. But the question came whether this action by the lottery online service provider was in compliance of the general data protection law or not. What court said, there is no valid consent by way of a pre-ticked checkbox which the user must deselect to refuse his consent. So even there was an option to deselect, but the action or the behavior of the online lottery service to give them induced to just go on is against the law. And then consent must be explicit and the controller be able to demonstrate that explicit consent is obtained. So it is the importance of the consent. So for a compliance perspective, again, it's important that we must know how to take the consent and how to be able to demonstrate, if required, that we have taken the consent. Next slide, please. There is an example of an employer in Netherlands who processed the biometric data, fingerprints of their employees without consent. So on the complaint, the case went to the Dutch Data Protection Authority that the employer has violated the law and he has not taken the consent before processing the biometric data. And the biometric data is the sensitive personal data for which some additional requirements are there to be met by the data controllers. So the employer took the very obvious defense before the authority that the machines which he is deployed for capturing the biometric impressions are from an ISO certified vendor and they are safe. And second, he says that the data is not misused. There is no hacking of the data. There is no breach of data. The data of his employees were safe, he says. So when there is no loss, no damage to the employees caused for not taking the consent, he say, please pardon me and do not impose some penalty on me. But on the other hand, what the authority says, it is on the next slide, please. The authority did not accept the grounds or reason taken by the employer, and the authority held that the processing of biometric data without consent has violated the relevant provision of GDPR. And the second important thing, the controller or the employer in that case must be able to demonstrate that he has obtained the explicit consent of the data subject. So next slide, please. Now, yeah, this is fine. So I'll just briefly, it's already much talked about who is controller and who is a processor. So these slides, this slide and next slide will give a brief determination how we can determine that one company is a controller or a processor. So there are some criteria to determine and to come to know whether a person is a controller or a processor. For example, if a person is able to make decision on the outcome of the processing, he's a controller. Another example is that if he is a person who is to take decisions about the national person based on their processing, that he is also a controller. There are a few other examples are there, but I'm not reading that all. They are simple. Can we go to the next slide, please? Again, the processor, I explained that the processor is a person who acts on the instructions and directions of data controller. So, for example, if he's not able to decide what data is to be collected, from whom is to be collected, and what are the lawful basis, what are the purpose of the, he's not deciding the purpose of the processing of data, so he's a data processor. Next slide, please. These are the example of processing. Just when I was talking about the definition of the concept of processing, I say it starts from the collection of data till its erasure. So these are all examples of the collection, processing of personal data, like collection of employees data, capturing fingerprints of employees for attendance purposes, capturing video images by security camera. When some visitors come to our offices, the security people get their ID card number or the telephone number. This is also the processing. Analyzing or sharing and transmission to others is also a part of processing. So next slide, please. Now, this is another important provision of the law. I would say it is the scope of the law. So this, the Federal Decree Law number 45 of 2021 of the United Arab Emirates is applicable on three cases. Number one, a data subject who has a domicile or place of business in UAE. For example, I am living in UAE, I have a domicile, I have a place of residence, so this law is applicable to me. Then a controller, on a second note, a controller or processor who is established in UAE and processing personal data of individual, importantly, inside or outside the UAE. So there are two conditions. The controller or processor must be established in UAE. What does it mean? That it must be established, a company have got a license or the trade license or the incorporation certificate to work in the UAE, and the controller and processor is processing either the data of the person in UAE or the outside UAE. And the third stage is a controller or processor who is not established in UAE. That means they have not gotten any business license or the trade license in UAE, but they are processing the data of individuals who are in the UAE. So on these three instances, this law is applicable. Next slide, please. This is the continuation of the earlier slide. The law, the instances or the authorities of the processing where this law is not applicable. The law is not applicable on governmental data or the governmental authorities, personal data in possession of security and judicial authorities, personal data being used by individual processing personal data for personal purposes. This is important to know because, for example, all of us in our mobile phone, we are maintaining a directory. So by definition, I determine to collect this data. I'm a controller. This is in personal data information, but for personal purposes, this is not included and the law is not applicable. On health personal data, law is not applicable. Banking and credit personal data is not applicable. And importantly, the free zones, which do have their own special law relating to the personal data protection. This law is not applicable except in example that for ADGM, which is a financial free zone, and DFC, which is also a financial free zone, they have their own specific laws. So these their own specific laws are applicable. Next slide, please. So the functions of the regulator are there. I will not go spend much of time on this. I will only say the prime function of the regulator is to implement and enforce the law, and in that connection, it can impose the penalties, decide the complaints, and settle the appeals also. So please, next slide. And next slide, please. I'll explain this. Next slide, please. So I have emphasized on the need of consent, but as Saifullah said, that these laws are an enabler. They do not restrict the processing of information, and that's why the law recognizes the instances or the circumstances when the requirement of consent may be bypassed, or which, or we can say the instances where the requirement of consent is not there. So these are necessity for public interest where there is no requirement to have the consent. Personal data made public by the data subject itself, so there is no requirement of the concept of consent comes arise. Necessity to initiate or defend any claim or rights and legal actions, judicial security procedure, there is no requirement to have a pre-consent. Necessity for occupational preventive medicine to assess working capacity of employees. The next slide, please. Necessity for the protection of public health. In all these cases, the consent requirement is bypassed and the data can be processed without taking the consent. So I'll come to the next slide, which is rights of the data subjects. So I'll spend some time to explain what this right means. So right to access to information. It means that what is the concept of right? Right means when a right is given to a data subject in law, it is enforced. That means if the data controller do not accept my request, so I can ask the authorities, I can knock the door of the authorities to enforce this law. So that's why the concept of the right is there. So the right of access to information is there, that data subject has the right to ask the data controller to give him access, what data is processing, for what purpose is processing, what controls he has maintained to protect my data. Again, the second right is right to request personal data portability. It means that my personal data kept with one data controller can easily be transferred or shared with another data controller. Right to rectify a result. If my data is incorrect, it is not correct, so I have a right to go to the data controller, say, please correct my data or to erase my data. Next slide, please. Right to restrict processing. It means that if I'm claiming as a data subject, if I claim that my data is not inaccurate, my data is inaccurate, so I have the right to ask to the data controller, please stop processing, restrict the processing till you have corrected my data. The next right is right to stop processing. This is very important right, that when, for example, I withdraw the consent, so I have the right to ask to the data controller that please stop my processing. Another important right, which is last one, is right to object to automated decision making. Automated decision making is a situation where some decisions are being made about a natural person purely on the basis of analytical analysis without application of the human mind. For example, a higher amount of traffic violation fine is imposed on a person who was a criminal based on his past criminal conduct without considering the present circumstances and effects of incidents. So the data subject has a right to object if he's being subjected to automated decision making. Next slide, please. This is about the obligations placed on the controller. Saifullah has already discussed this, but this slide shows these are the 7 principles which a data controller is obliged to follow. Number 1 is the lawfulness, fairness, and transparency. The data must be processed on the lawful basis and openness and transparency. Giving access and accepting the request of the data subject as being data right is one component of the fairness and transparency. Then there is a concept purpose limitation, that the data which is originally obtained for what purpose, it cannot be used for any other purpose. Data minimization is that we can keep only the minimum amount of data required to fulfill that purpose. Accuracy is that the data must be accurate with respect to its context. Storage limitation is that if I ask the data for a particular purpose and this purpose is finished for 6 months, for example, so after 6 months I'm not obliged to keep this data beyond. Security is about the data personal protection of personal data. The data controller is obliged to take all security measures, technical and organizational measures to ensure the security of the data. And the accountability important. The data controller and data processor are obliged to make are accountable for their action. Okay, fine. And the next slide, please. We talk about the protection of personal data just in case there is a breach. So what has to be done? So in the case of breaches, in certain cases, the data controller is to notify the incidence of breach to the relevant regulatory authority. And these are 4 instances when he is required to report the breach to a data regulatory authority: when there is a risk to privacy of the data subject, or there is a risk to confidentiality of the data subject, or there is a risk to the security of the data subject, or there is a risk to the rights of the data subject. Next slide, please. What needs to be done, it is mentioned in this slide. We can see that while making a data breach notification, a data controller is to describe the nature of the breach, what likely effect it has done, and importantly, what measures data controller has taken to rectify or remedy this breach. My last, next slide, please. As of now, the Federal Decree Law of number 45 of United Arab Emirates has not specified the amounts of fines. A cabinet decision is yet to be issued, which will define what is the violation and what is a relevant fine. Just very quickly to give an idea to my audience, in the next slide, please, I would like to show what are the level of penalties and the administrative fine in other regimes. For example, GDPR across Europe, the maximum penalty for the contravention is 20 million euros or 4% of the global turnover, whichever is higher. In ADGM, it is maximum $28 million, and for DIFC, Dubai International Financial Centers, the maximum amount of penalty is $500,000. So thank you very much, and my presentation, and now we'll welcome the question put by our audience.
Thank you very much for that, Saeed. I think just looking at the time, we should have time for just 1 or 2 questions from the audience, and we have had a number that have come in. So if you've sent in a question that we don't have time to answer, they will be sent onto the panel and we will be in touch. And we do encourage you to get in touch with the panel as well. You can see their contact information there. If I ask this first question, which came in from Manish, is UAE federal data law applicable on employees' data for banks and healthcare?
Okay, if you allow, I'll take this question from Manish. Actually, the UAE federal data law is not applicable on the banks and the healthcare. But at the same time, why this is not applicable? Because the Central Bank of United Arab Emirates and the Health Department has its own set of regulations to protect the personal data of the customers of the bank, which are consumers, and the patients of the health department. So whatever is not subject matter of that regulation issued by the health department or issued by the Central Bank of UAE are to be subject matter of this law. So coming to his specific question, whether employees' data for the banks and healthcare is subject to UAE law as long the UAE the Central Bank of UAE or the health department do not provide any specific provision to deal with the personal data of the employees of the bank or the healthcare service provider, then this law will be applicable to that extent.
Excellent. Thank you, Saeed. Our final question I will direct to Alfred. I hope you'll be able to answer it. If not, we can certainly follow up afterwards. This is in from Moeen, and he just asked, and I think this is in reference to your presentation, what is meant by binding corporate rules? I think you're on mute at the moment, Alfred.
Pardon, I beg your pardon. Sorry, I'll repeat that. Thank you very much. This is a very valid question. As you can see in the action of adequate decisions pursuant to Section 41 of the ADGM, what they mean here by including binding corporate rules, as you know, whenever there are laws and regulations put in place, this laws and regulation has to be part of your corporate structure and policies and procedures. So they want to make sure that when you transfer data out of ADGM, that corporate entity or that bank or that entity has proper corporate rules and regulation and policies in place that they keep the data well protected. Hopefully that.
I would just like to add and to supplement the comments of Alfred about the binding corporate rules, only with the requirement that these binding corporate rules are approved by the relevant regulator.
Excellent. Thank you, Saeed, and thank you, Alfred. Just looking at the time, I think that we will need to wrap up at this point, but thank you very much for sending in those questions. As I say, they will be sent on to the panel who will be in touch. We will also circulate these slides with the contact information and a recording of this session to you. If you do have any questions, please do get in touch. But I would like to extend my thanks to Saeed, Saifullah, and of course, Alfred, for your fascinating presentations and your insights and your time today. I really hope we can have you back again soon. And I would like to thank you for being with us today. We really appreciate it. So thank you once again. Please do get in touch if you want any of your questions answered. But I will say thank you again and have a lovely rest of your day. Goodbye.
Thank you,
Goodbye.
Dan.
Thank you, Dan. Thank you, Dan, and
Goodbye.
thank you all
Thank
the
you all.
participants for attending today's session.
Thank you.